Hey everyone, and welcome to The Explainer. Today, we are jumping straight into something that has a lot of people talking right now, which is the Kenya Competition Amendment Bill of 2026. Now, if you track the economic or policy landscape in Kenya, you know these legislative documents can feel like a total maze of legal jargon, right? So what we're going to do is unpack this dense policy proposal and turn it into something clear, visual, and easy to digest. But before we get into the weeds, I need to emphasize right out of the gate, these are entirely proposed amendments, okay? They are not currently in place. But they do signal a massive, massive shift in how business could very soon be conducted across Kenya. So grab a coffee, get comfortable, and let's decode the future of Kenya's digital and commercial markets. To keep us on track, we'll be using our standard policy breakdown framework. We'll start with the context, then look at regulating digital markets, superior bargaining and buyer power, mergers and consumer welfare, enforcement and penalties, and finally, what happens next.
Section 1, the context and the need for new rules.
So let's set the baseline here. For over a decade now, the current Competition Act, which originally dates back to 2010, has actually served traditional markets really well. You know, it was built for brick-and-mortar stores, traditional manufacturing, standard supply chains, the physical stuff. But obviously, the economy has evolved at breakneck speed since then. The Director General's submission to Parliament makes a really explicit point about this. They noted that while the digital economy brings huge opportunities for things like financial inclusion, the current act simply doesn't expressly provide for the regulation of competition in digital markets. We're talking about virtual marketplaces that have literally exploded in growth. This sudden rise created massive regulatory gaps. We're seeing risks with market power concentration and these totally unique barriers to entry that the old 2010 rules just weren't built to handle.
And this brings us to a really powerful quote from the Director General's submission. They stated, "It is therefore necessary for Kenya's competition framework to align with these regional and continental legal frameworks and so on to ensure a level playing field." Essentially, alignment is the name of the game here. Digital markets are cross-border by nature, right? Platforms operate across multiple jurisdictions seamlessly, which puts them totally beyond the reach of just one country's domestic rules. Since Kenya is a state party to both COMESA and the AfCFTA, the African Continental Free Trade Area, and those bodies already have competition regimes that tackle things like self-preferencing in digital markets, Kenya's basically proposing an update to its own software. They want to be compatible with the rest of the continent. Moving on to Section 2, regulating digital markets. Obviously, the first step in regulating anything is defining what it actually is. So the bill introduces this brand new comprehensive definition for digital activity. It defines it as providing a service through the internet or digital content, whether you're charging for it or not, and whether it's a multi-sided platform or not. This is a wide net. It explicitly brings a massive range of platforms under the regulatory microscope. We're talking app stores, search engines, social media, video sharing platforms, operating systems, cloud computing, and online ads. Basically, if you run a platform that sits between a buyer and a seller virtually, you're going to fall into this newly proposed category. Now, I really want you to focus on this number here, 40%. This represents an absolute paradigm shift in antitrust thinking. Under traditional Kenyan competition law, if a company controlled less than 40% of the market share, they generally were not considered dominant unless someone proved otherwise. But, as we know, the digital world plays by totally different rules. The proposed bill changes the criteria for digital markets specifically, stating that a firm could control less than 40% of the market share and still be considered to have market power, or what the bill calls a strategic market position. Why? Because digital platforms get massive competitive advantages from things that have absolutely nothing to do with pure market share. So how do they actually measure that? The authority plans to use some highly sophisticated new criteria to determine if a platform has a strategic market position. First, they'll look at network effects. Basically, does the platform become more valuable just because more people use it? That creates a huge invisible barrier to entry for anyone new trying to compete. They'll also look at economies of scale. And this is a big one, the platform's access to data. Data is king here. Then there's user switching costs, like how annoying is it for a user to move to a competing platform? They'll also weigh the competitive pressure driven by innovation and just the sheer importance of the platform as an intermediary for businesses trying to reach customers. It's a really nuanced approach. They're looking way past the traditional balance sheet and digging right into the actual mechanics of a digital ecosystem. Section 3, superior bargaining and buyer power. Let's pivot slightly away from just the digital space and look at the broader business-to-business or B2B ecosystem. This is all about fairness, and it's best framed as a David versus Goliath scenario. Look, the current act already outlaws the abuse of dominance. But remember, dominance implies you have a huge chunk of the overall market. What this new bill asks is, what if a larger company isn't dominant in the whole market, but they are absolutely essential to one specific small supplier? The current act couldn't really help there. It didn't prohibit the abuse of a superior bargaining position. This meant the authority was kind of stuck when a big business imposed brutal terms on a weaker, economically dependent partner, like an MSME, your micro, small, or medium enterprise. This proposed bill steps in to protect that specific, unbalanced relationship, ensuring larger buyers can't just exploit their leverage over smaller suppliers who have nowhere else to go.
And they get very specific about what is not allowed. Here is the prohibited conduct under the new unfair market conduct section. Number 1, delaying payment without a justifiable reason. We all know that for an MSME, a delayed payment isn't just an inconvenience, it can literally mean bankruptcy. Next is unilaterally terminating a commercial relationship without notice, or on unreasonably short notice. Then, unjustifiably refusing to receive or return goods. They also prohibit transferring commercial risks or costs onto the supplier, so a big buyer can't force a small supplier to foot the bill for promoting the buyer's own goods, for example. And finally, demanding unfavorable preferential terms. The bill even goes so far as to require that contracts between buyers and suppliers explicitly include payment dates and termination conditions. It's really about forcing transparency into everyday transactions.
On to Section 4, mergers and consumer welfare. We have two really quick but very significant shifts here. First up, the bill broadens the definition of a merger to explicitly include the privatization of government agencies and state corporations that engage in trade. So if a state asset gets sold off to a private company, the competition authority gets strict oversight to ensure that sale doesn't just create a new monopoly. Secondly, there's a terminology change. The bill replaces the word complaints with consumer welfare issues. The Director General noted this is to align with international best practices. It's a shift from just reactively handling individual gripes to proactively regulating the overall welfare of consumers in Kenya. And speaking of consumer welfare, the bill really tightens the leash on corporate disclosures. Under the rules for false or misleading representations, they are proposing a brand new offense, withholding material information on the quality and use of a good or service. Think about that for a second. Previously, you got penalized for actively lying or making up facts about a product. But now, omission is just as illegal. If you hide a crucial flaw or hide information about how a product is actually supposed to be used, you are directly violating this proposed standard. Section 5. Enforcement and penalties. Because honestly, a regulation is only as good as its enforcement, right? And 10 million is the critical number here. The proposed bill is giving the authority some serious teeth. If an entity is convicted of abusing buyer power or a superior bargaining position, like we talked about earlier, they are looking at a fine not exceeding 10 million shillings, or imprisonment for up to 5 years, or both. Plus, the bill wants to give the authority the power to enforce administrative sanctions directly against violators. The message they are sending is pretty unmistakable. They want the statutory power to back up these fair market rules with severe, undeniable consequences. Which brings us to our final section, Section 6, what happens next? We've covered a ton of ground, from digital ecosystems to small business protections. But where does this actually stand? Again, I want to emphasize that these are just proposed amendments right now. Looking at the timeline, the bill was drafted and proposed in July 2026. Then, in a really crucial step, the Parliamentary Committee on Finance and National Planning called for submissions from key stakeholders. That specific public participation window happened between July 21st and July 23rd. The authority noted they've done extensive consultations and have been baking those recommendations right into the bill. So what's left? It's currently pending parliamentary debate and voting. That's the make-or-break phase where lawmakers actually decide if these massive structural changes become the new law of the land. And that wraps up our breakdown for today. Look, whether you're an entrepreneur, a supplier, or just someone fascinated by digital economics, this is something you absolutely need to keep an eye on. For deeper analysis and to use a really fantastic policy tracker to watch how this bill evolves in Parliament, you should definitely check out our website at www.ntpi.nexustechpolicyadvisors.com. Before I go, I want to leave you with one thought to chew on. If this bill actually passes as it's proposed right now, how do you think redefining market dominance will fundamentally reshape the next decade of digital innovation in Kenya? It is a fascinating question, and one we are going to be tracking very closely. Thank you so much for joining me on this explainer. Keep learning, and I'll catch you on the next one.